matter of S children.
Give us a moment.
Okay.
Okay, please proceed.
Good morning, Your Honors. My name is Jean Kaiser, and I represent the appellant mother. The question before this court involves federal immigration law as it applies to unaccompanied refugee minor children, and it doesn't just apply to these appellants. This court's decision will inform parents and refugees in refugee camps all over the world who are in the process of making the excruciating decision of whether to send their children to safety in the United States, whether a Massachusetts probate court will have the authority to permanently sever their relationship with those children if they themselves can reach the United States.
Ms. Kaiser, just out of interest, I looked, but I couldn't, is there no court has dealt with this issue?
Surprisingly, Your Honor, no.
I mean, it's been around a long time. I mean, I find that astounding, but I couldn't find anything.
Correct, and so this court's decision in this case will be of great importance because its decision should ensure parents in refugee camps all around the world that Massachusetts courts will enforce the existing law as it exists that prohibits termination of parental rights of children in the unaccompanied refugee minor program.
The issue is not whether we will enforce existing law. The issue is what is the existing law.
What is the
So why should we not interpret the regulation to mean that if you are in, let's say, Syria, and your parents are missing because of the chaos of war, and they come to this country, that when, hopefully soon, perhaps not so soon, the parents are able to reunite, they're not going to learn, oh, you were gone for so long that we've allowed your children to be adopted. I understand that principle, but what if the parents themselves have been deemed to be unfit to be their parents? How can they be reunified with children if the parents themselves are unfit to be parents?
Well, Your Honor, I don't think that there can be a determination that a parent is unfit somehow outside the courtroom. And the way that the regulation of the Office of Refugee Resettlement is written does not provide for termination of parental rights unless in instances, where the parents are missing or missing.
That's for example. It isn't.
Non-exhaustive list.
It is a non-exhaustive list, but in a non-exhaustive list, the other examples must be of like kind. It's not a springboard for endless opportunity to terminate rights under any circumstances. And the way that DCF and Children's Council would have this court read the regulation is that the same rules that apply to domestic children should apply in the cases of refugee
But these
minors.
parents are not somewhere else. They're here in the United States. So are the children unaccompanied refugee minors?
Yes, Your Honor, under the definition of unaccompanied refugee minors, they remain in that status unless they are reunited with their parents or they reach age 18 or an adult.
I thought the definition was that the parents are either no longer living or parts unknown. It's known where they are.
That's true when they come to the country, and that was true for these children when they came to the country. But the definition of when unaccompanied refugee minor status ends says that it ends when they reach 18 or they're reunited with a parent or there's a legal guardianship.
So you're saying, you're interpreting the definition of unaccompanied minor that if it fits you when you come, it never changes. Is that right?
No, not that it never changes.
Well, I mean, you continue to qualify unless you fit within, you turn 18 or something else. But the fact that they may have been unaccompanied minors when they came here, but their parents are now here, so that last clause of the definition no longer applies. You think that's irrelevant?
Well, I think under the regulation it's irrelevant. I think the regulation controls when unaccompanied refugee minor status ceases, and none of those criteria exist here. So I think these children are still unaccompanied refugee minors as the federal regulation defines it.
when you say none of the criteria arrives here, certainly the Code of Regulations talks about it being a rare situation and an exception and all of that, but they didn't just list 2 reasons. Here you have parents who are not in poverty in another part of the world or strife or political situation. They're right in the country.
Well, Your Honor, the regulation does not distinguish on the basis of whether the parents are in the country or outside of the country. To read that into the regulation, it would essentially require this court to read in a term. If you look at the regulation, it says that adoption of these children should be rare. It should occur in only certain rare instances, and only when a court finds adoption is in the children's best interest and there is termination of parental rights. Not that the court would find that there should be termination of parental rights, but that there is.
Well, there can't be unless there's a proceeding to do it.
That is not entirely correct. There would be termination of parental rights if the children's parents were dead, if they were missing or presumed dead. There could be other examples, for instance.
So
if
you think it doesn't mean termination pursuant to court procedures?
No, I do not think that it could possibly.
Term of art? Wouldn't you think that termination means something different than death?
I think if you look at all of the circumstances surrounding this regulation, most particularly that there would be no need to have this regulation at all if we looked at, there always must be termination of parental rights if a child is to be adopted. But this regulation doesn't say when a court terminates rights. It says if it's in the child's best interest and there is termination of parental rights, for instance, and it gives 2 examples. And again, those examples indicate when circumstances in which termination of parental rights has occurred through operation of law, not because the court has decided rights should be terminated.
But Ms. Kaiser, don't you think it seems to me that the phrase termination of parental rights is a reference to a court proceeding. Somebody has to, a court has to determine, have these parental rights been terminated? It's a legal term, and that's what it means.
I think the role for the probate court here would be to determine had parental rights occurred. Because certainly the probate court might have to determine, is there sufficient evidence that the parents are dead? If another circumstance where termination of parental rights may have occurred is if the parents had voluntarily surrendered. The court would have to determine whether or not that surrender.
Let's take this case. Let's just say that these children, they'd been here 10 years. They're still minors by quite a bit. Their parents have been here 10 years. They've made no, as far as I can tell from the record, they've made no attempt to try to get custody of their children or contact with their children. It was the agency that contacted them. So they just go along in foster care until they turn 18 and then they're let go? I mean, it doesn't make sense.
No, Your Honor, and I think that's an important distinction. The regulation does not preclude permanency for these children. It precludes permanency through adoption. Permanency is still available to these children, for instance, by legal guardianship. So these children could become, their foster parents could become their legal guardian, and then they would no longer be in the care of the state. And I think the important consideration here is we have to think of, this is about the court's authority. Does the probate court have the authority to terminate parental rights here? I think the regulation clearly says only in these rare and specific circumstances does it have that authority.
Why would the regulation be more pertinent here than the statute, the Adoption of Safe Families Act?
Well, Your Honor, with regard to the Adoption and Safe Families Act, the appellees point to a single provision in a very broad statute that simply says that when children have been in foster care for a lengthy period of time, the department must file a petition to terminate parental rights. But in the same breath, the department does admit that it doesn't have to do that, and in particular, it doesn't have to do that when children are in the Unaccompanied Refugee Minor Act. But I think in some ways that the ASFA is a red herring here, because Once the petition goes before the court, the federal regulation, again, acts as a stop sign. It says that termination of parental rights should only occur in those rare instances where there is termination of parental
May I
rights.
ask you, I want to go back to the definition of unaccompanied refugee minor. You have the parents here as parties in this case, so I'm just wondering how the parents can have it both ways. They can be here, represented, but they want to say that the children are unaccompanied refugee minors. I don't understand how that works.
I think we have to look at the big picture behind the regulation, and I think we have to look back to the time when a parent of a child is trying to make the decision, should I send my child to the United States? That parent does not want to be faced with the circumstance that if I send my child there, the child is safe, and then I get to the United States, well, all bets are off. My rights might be terminated. And you know, if you, even looking at this particular case, the parents were, the mother, my client, was settled in North Dakota and her children were in Massachusetts. That obviously is a barrier to reunification. There could be other instances where a very small child is brought here, is in foster care. Well, under our adoption law, one of the elements or considerations in parental unfitness is whether the child has developed a long-standing attachment to a foster parent and the parent is not prepared to deal with the psychological harm that could occur if the child is taken from foster care. So in that circumstance, a parent who sent their small child to the United States could be found unfit by a court and have her right to that child terminated. I think that when you look at the big picture here, it is clear that the federal regulation is set up to help parents in that situation, in that very terrible situation, make the decision that they can safely send their children here and that they can be reunited.
But that has nothing to do with the question that I asked you. I'm trying to figure out how it is that a parent who is here, how can that parent then say that my child is an unaccompanied refugee minor, because it's not the case that the parent is somewhere else. The parent is here.
That's correct, Your Honor. The parent is here, and the parent received counsel, and counsel brought to the attention of the probate court judge that
But doesn't the parent have some obligation, if they're in the country, to avoid the application of the regulation to their child?
I think that the parent, and because the parents in this case stand here as appellants, they're showing that they are not disinterested in these children. They do want a relationship with these children. But the parents certainly are entitled to raise the fact that they have that their rights have a certain protection under the federal regulations.
I mean, as I read the regulation in line with the policy statement, or I don't know its full name, but it seems to me that the parents that the statute and the policy is seeking very much to protect against losing their children are the parents who are in other countries who, for safety reasons or whatever, send their children here. They're perfectly capable parents. They can't get here, and it would be terrible if this country took away their parental rights. That is not this case.
Your Honor, it may or may not be this case. We don't have many facts before
But
this.
we have the parents in this country.
But in these circumstances, it may well be that the Office for Refugee Resettlement should amend its regulations in order to provide more guidance in a situation like this. Although the guidelines that you speak to, the office was asked to amend its guidelines to provide more guidance, and it decided to keep the same guideline.
Didn't the Secretary of Health and Human Services have something to say about that as far as giving some guidance and talking about termination of parental rights provisions that Congress has developed apply to all children, meaning all children would include children within this program?
Well, I think what the secretary said is that he did not have the statutory authority to exempt children in the unaccompanied refugee minor program, but unaccompanied refugee minor status may provide a compelling reason for a state agency not to file for termination of parental rights. I would say that DCF has elected to follow that rule by passing its own regulation.
That's not how I read it. That's not how I read it. I'm talking about the 45 CFR 405, and that's not how I read it. I thought what it said was that the termination of parental rights provisions apply to all children in foster care.
I do not think that, I'm not sure exactly which regulation you're referring to, but I don't.
5 CFR 4059.
4059. If I'm, there's a lot of regulations here, and I may not be recalling the exact one, but it does say with regard to filing a petition. But I think then the federal regulation governing unaccompanied refugee minor children does apply. And I think to find otherwise would allow probate courts all over the country, not just in Massachusetts, to in a piecemeal fashion, apply the federal law that governs unaccompanied refugee minor children, which I think would be a problem with federalism.
All right, thank you.
May it please the court, Brian Pariser on behalf of the Department of Children and Families, and I'll be sharing my time today with Counsel for the Children, 10 minutes and 5 minutes. I would like to make 3 important points this morning, and the first goes to the initial question raised by Justice Botsford, and that is the rarity of this situation and why it has not appeared. And that's very important because the federal regulation, ORR's regulation, employs the term rare. And just to put that in context, I can't speak for the other 49 states, but to put that in context in the Commonwealth at least, this court should know that at present, and this varies obviously from time to time, but we have about 160 cases involving unaccompanied refugee minors, 160 cases.
So these are,
I'm sorry?
okay, these are children who've been placed here and then, and they are in your custody.
Placed here by the federal government, placed with the expectation that the department would initiate a custody proceeding, as this court addressed last year in custody of Victoria.
So that child, Victoria, it's the same program?
She is one of the children in that program.
But
who,
it has to be rare within that group, not just that the group is rare.
and I just stopped to answer Justice Bosford's question. I have that statistic as well, and I just want to be clear that in the time that Massachusetts has been partnering with the federal government to service these children, we have initiated termination proceedings in 3 cases. 3 cases, including this case. Out of 160 presently, we've obviously been doing this for a number of years, so the number of cases that have come through Massachusetts has exceeded 160. 3 total that we have initiated. That speaks to the rarity of this situation.
And of the 3, how many of them were being terminated because of the unfitness of the parents?
2 out of 3. I believe one of them would involve a case of death of the
Yes,
parents.
so 2 out of 3. And with regard to both of those 2, were the parents in this country at the time?
Obviously, in this case, the parents
Right.
are. With regard to the other one, I believe there may have been a question of whether they have been out of the country. I could get that information for the court specifically.
How did they manage to, if they're not in the country?
How is there an adjudication of their
Yeah.
unfitness?
And I understand it raises a whole host of questions that aren't in this case. I'm not prepared to answer that. That's another case, and I don't have the facts. I brought the
But I mean,
statistic.
but it raises a concern in that there would be a concern if somebody were, say, still in Syria and somebody was claiming they were unfit for whatever reason, they would, of course, not have a chance to be heard, and the fairness of the adjudication would be at issue. So I'm trying to get a sense of how far you want us to stretch with regard to this
Well,
decision.
that would be one case, but I do acknowledge the fact that clearly there are a whole host of facts that could make that problematic. But I could also imagine a set of facts where just because a parent is overseas does not necessarily make it an unfair process. I do not know what the input those parents had, what the notice issues were. Those would be things that one would look at, I assume, a court, that would go to the question of whether it would be appropriate to pursue a termination proceeding. In any event, that we are talking, I give you those numbers merely to say that the system is operating under the presumption that this is the rare situation that we go forward in,
And
at least in Massachusetts.
what do you say, because obviously you are treating this child or these children as unaccompanied minors, to Justice Hines' question of, since that last clause of the definition of unaccompanied minors does suggest that the parents aren't here, and these parents are, do they still fit the definition?
I think it's important to notice that just because these children are serviced through the unaccompanied refugee minor children, it does not necessarily mean that they are either unaccompanied or refugees. Okay, that's a bit of a term of art. It's a program that was set up, and clearly, as this court knows from Victoria, the child in that case was neither unaccompanied nor a refugee. Right. Her mother, she was removed from her mother's care in Texas. So just because a child has been housed, and the federal government acknowledges that this program that may have originally been set up to house unaccompanied refugee minors could be used for other children who are brought into the country by the United States government. So we can get into a definition of whether there are under the statute, largely that's...
They continue to be treated in the same program, even though they may not fit every piece of the definition.
That's correct, and the federal government acknowledges that once they are in the program, they may continue to be serviced by the program, but that doesn't necessarily mean they are unaccompanied, and they are not unaccompanied in this case. And I would like to...
You had 3 points. You have
Yes, thank you.
one so far.
Thank you. The second point I would like to particularly remind this court of is we are dealing, obviously, with ORR's regulation. That's 400 CFR 400-115C. That regulation employs the term rare, and on its face does not prohibit the termination of parental rights. And particularly if one is looking at the plain language, I would point that, as my sister did, that it talks about provided a court finds adoption would be the best interest of the child and there is termination of parental rights, it breaks for a parenthetical to explain, and we may dispute whether that's exhaustive or illustrative. But if you remove that parenthetical, you finish the sentence, or the clause, that says there is termination of parental rights as determined by an appropriate state court. Okay? There is an understanding on its face that these questions will be resolved by state courts. The federal government hands these children over to the states, requires that the states go to state court to adjudicate their custody, and clearly wishes state courts to resolve these questions. And the question of whether it's a rare situation, I would submit, is a question of fact. And that is one to be determined by the state court through the trial. But if that's not enough on its face, I would ask this court to defer to ORR's own interpretation of its regulation. And again, just to cite Auer versus Robbins, the United States Supreme Court in 519 U.S. 452 in 1997 said that courts defer to agencies' interpretation of their own regulations. In this case, as recently as 2012, ORR issued this subregulatory guidance that's referred to in everybody's brief, and throughout this guidance lingers the expectation that children may be subject to termination proceedings and may be adopted. It says, ORR says, it cites on page 3 of the guidance, and I quote, ORR, taking into consideration the wide number of variables in state law throughout the country, believes that such cases must be decided on their own merit on a case-by-case basis by local courts empowered to make such decisions based on state law and the best evidence available. And if that was not enough, I would submit that further on page 7 of that guidance, there's a section that is titled Legal Considerations and Legal Responsibility, and it talks about establishing responsibility, and under paragraph 5 of section A, it reads, procedural safeguards exist that ensure that when the rights of minors' unavailable parents are protected and are not terminated as long as reunification with the parents remains reasonably possible as determined by an appropriate state court. Now, if in fact the appellants were correct in reading this regulation in the most restrictive fashion to apply only to dead parents, we would not need guidance from ORR to protect the procedural rights of dead parents. That only exists when a court is making a determination, and it can address Chief Justice Gantz's concerns about due process, about notice, about participation of parents overseas. That raises questions of whether parents' rights are protected or not. But again, the number of cases that could come before the probate and family court are as varied as you can imagine in the facts that might satisfy a court that those protections have been provided or not. The fact is in this case, we have parents that are in this country, we have parents that have received notice of these proceedings, that have received counsel, that have been in touch with the department that is exercising custody of their children for a number of years.
As a practical matter, I was just wondering about this. Let's say your view prevails, and so there will be a proceeding in the probate and family court on the parental fitness. What kind of, at least from this record, all we have is something written in 2008 or 10 about the parents in the foreign country, Bhutan. But what kind of investigation does the department do when one is in Wisconsin, one is in North Dakota, and one is in Chicago?
North Dakota and Ohio, I believe,
Ohio, yes, right.
according to the record. But simply put, not only have social workers been in contact with the parents, and there have been phone calls, but state law in all the 50 states provides for the interstate compact on the placement of children, which means that the department I believe, has initiated a home study of the parents in those states. So there will be evidence from home studies from social workers in those states who have visited the homes. There will be, obviously, the interactions that the Massachusetts social workers have had with the parents. There will be evidence regarding the children and their special needs. And then, of course, there will be the period of time that the parents have not been in contact with the children on its face. I leave that to the trial court to discuss that in depth, but there are mechanisms for gathering, obviously.
The passage of time can't be the determinant, because if they had been in Syria or in this case, I guess, Bhutan, but, I mean, people can be stuck in Syria for 10 years, and one would hope that the passage of time would not be viewed as sufficient.
Sadly, that is true. However, I would submit that the passage of time for someone in Syria is not the same for the passage of time in someone in Ohio.
North Dakota, okay.
And that would be a different consideration.
That passage of time.
And just for 2 seconds, I would say the third point that I had never gotten to is simply that to read the regulation as the department suggests brings it in line with the Adoption Safe Families Act. So again, we have guidance from the Secretary of Health and Human Services, we have guidance from the United States Congress, and to restrict this regulation to not allow the department to seek termination of parental rights in factual situations like the one here would fly in the face of the Adoption Safe Families Act.
Although, I mean, one can say that the act, I don't know the full name of the Unaccompanied Refugee Minor Act is, but it's very specific about the goal is family unification. I mean, it has a very specific and articulated purpose.
And I would submit that goal of reunification is the same for every child in foster care. Our own statute, 119 Section 1, creates the first obligation of the department and the child welfare system is to pursue reunification. And under the federal law, the state has to show reasonable efforts to reunify, and that's contrary to welfare for the child to be in the home. So those obligations apply to all children in foster care. Thank you very much.
All right, thank you.
May it please the court, my name is Nina Negron, and I represent the children. I just want to start by saying that these children have been lingering in foster care for over 5 years now. They've consistently made their wishes clear that they want to be adopted. My oldest client will be 17 years old in February, and she's requesting an expedited decision, given the trial court has stayed these matters so that this court could make a decision. The parents have not made any attempt to reunify with their children since 2003. That is what we have in the record in terms of the time that they entered the United States.
2003?
I'm sorry, 2013, Judge. And as this court knows, since the parents have entered the United States and have been residing in the United States, they've had very little contact with their children. I agree with my brother, who represents the department, that the federal regulation unequivocally permits the Department of Children and Families to pursue a termination of parental rights petition against the parents. And these rare cases are here. And certainly, I know that mother's attorney wants the court to believe that this would open up the floodgates for a number of parents who are stuck in these war-torn countries or in political and social upheaval, separated by their children, by circumstances beyond their control. And obviously, what makes this case a real game changer is that the parents are here, and the federal regulation makes that exception. It makes that exception by saying in rare circumstances. It refers to the state courts to make that determination. The state courts have jurisdiction over these children. The Office of Refugee Resettlement places these children in these states, giving the state court the opportunity to review and make a determination on a case-by-case basis, just like my brother has mentioned.
Interrupt you. As I understand the mother's position, though, the unaccompanied refugee minor program, the goal is not to have the child be in a difficult situation. The child would be in foster care and could be there for a significant period of time. The mother's position is that the cause that would allow for adoption has to be something other than a judicial cause. I think that's what their argument is.
Well, right, she talks about these non-judicial means of termination. First, we look at this federal statute, and it mentions best interest of the child when balancing termination of parental rights. It does mention in this statute the state courts, that this is left up to the state courts. It uses these examples of dead or presumed dead. That is not the case here. That's one of the reasons why this case is rare, because the parents are not dead, because the parents are not overseas. They're in the United States. But it's not mutually exclusive to those examples. Those are just examples. And had the legislator decided that these would be exclusively mutual provisions of this regulation, they would have said so in that regulation. I think that the Office of Refugee Resettlement expands and further explains, just like my brother has mentioned, that state courts are more equipped to make the determination. And since the Office of Refugee Resettlement in its policies and guidelines and priorities expands and clarifies upon this very same matter that the regulation mentions, it's very clear that this is more than just when a parent's rights being terminated because of death or a presumption of death. It has to do with court proceedings. It has to do with evidence, witnesses, the merits of the case. And that's really what the Office of Refugee Resettlement explains. This won't open the door, the floodgate, for parents abroad, because those parents are not in the United States. And that's a real game changer here. They're not here, and that's the whole purpose of the unaccompanied refugee minor program, to preserve those children so they can be reunified with their parents when their parents do enter the United States. But we have to think about the best interest of the children. When the children are lingering in foster care for over 5 years, and their parents have been in the United States since 2013.
Thank you.
Thank you. I will rest on my brief.